Yes, we apologize for the late start. It is an attempt to switch from what I had hoped was going to be an electronic-minded approach to a devastation of forest and paper approach. But we think everybody now has the relevant documentation that they require before them today for this inquiry. Maybe before I call our first witness, from media reports, if anybody would like a copy of the terms of reference of the inquiry, we'd happily provide it, because there seemed to be some confusion on the basis upon which the inquiry had been constituted. It is not under the Commissions Act, but under Section 12(6) of the National Prosecuting Act, and that might assist in ensuring that the terms of the reference of the inquiry is understood. But as our first witness, we'd like to call Advocate Jan Ferreira, who's prepared to give evidence and take the oath.
Would you please state your full names for the purpose of the record?
Jan Ferreira.
Do you swear that the evidence that you shall give shall be the truth, the whole truth and nothing but the truth? So raise your right hand and say, help me God.
So help me God.
Good morning, Advocate Ferreira.
Good morning.
Madam Chair, before we commence with the evidence, my colleague, Advocate Masuku, would just like to address the inquiry.
You may do so, Mr. Masuku.
Thank you, Chair. As we prepared for this witness, Madam Chair, we were faced with the difficulty of trying to find our way into cross-examining him, particularly on what appears to be a pending criminal case that is still not finalized. What I am instructed is that there is a decision which sits in the office of the acting NDPP regarding the very issues that will be canvassed by with this witness. And that decision may well be that the criminal trial must proceed or that it must not proceed. Either way, we have problems, because if the decision is that the criminal trial must not proceed, of course then, you know, what is giving us opinions of his that may not well take the matter any further than just telling us how committed he was to ensuring that he prosecutes Advocate Jiba. But if the decision is that the prosecution should proceed, we have problems, because this is important for us, because it informs how far we can go with him. We don't want to put statements to him that may well affect our rights when we appear before the criminal case, especially if he's reappointed as the prosecutor in the case. It would seem to us that it's inappropriate for him as a potential prosecutor in the case to be coming to deal with a matter that he will be dealing with in a criminal case if he's given that opportunity. So that's where we are. What we would have wanted with the instructions that we have is, if this commission had could encourage, sorry, if this inquiry, I apologize, I'm also a victim of the media reports now, so they call it a corruption commission. But if this inquiry could encourage the office of the NDPP to release that decision, because it's material in how we engage with this witness on the issues. Because what they're asking you to do now, or what his evidence would be, if the decision is to prosecute is refused, or rather it's withdrawn, then then you would want this witness who has withdrawn the decision to come and explain and deal with whatever evidence Mr. Ferreira provides by way of encouraging, by way of his support for a prosecution of Advocate Jiba. And I think if
there is no prosecution, if the decision is not to prosecute,
yes,
then that person would then come and explain, as opposed to what this witness would
so no, you're potentially.
I'm trying to understand. Sorry.
Yes, no, I'm glad that you asked the question.
Yeah.
But so what you have here is a one-sided opinion of one prosecutor. A more senior prosecutor may come to a different decision on the matter. And to be asked to make a decision on the basis of a one-sided view of one prosecutor on the same matter may not entirely place you in a position where you are able to balance the various views that relate to whether or not it was correct for the prosecution to proceed. So your evaluation of whether there was a basis on which Advocate Jiba should have been charged is only based on what Ferreira tells you. But if there is a contrary decision to that of Ferreira, which there is in fact, but we want a formal one from the office of the NTPP, from the office of the NTPP, right? Yeah, the acting NTPP. Because if it's before the inquiry, it would help to then know how to engage with this witness on his belief that there is a basis on which to cross-examine, on which to prosecute Advocate Jiba, which runs contrary to a potential decision not to prosecute. So we're just placing that as a point that would hamstring us in cross-examining him on the issue relating to the prosecution of Advocate Jiba. Because obviously there are fair trial rights that are involved, so you have to balance all those things.
Okay, thank you, Advocate Masuku. Ms. Bauer, how would you like to respond to that?
Well, I am aware that there is a possibility of a criminal trial ensuing in the future. I would be reluctant for anybody to be interfering with the independence of the prosecuting authority into how, when, what that decision should entail. So I wouldn't want the inquiry to make any overtures to the National Director of Public Prosecutions in respect thereof. But I am cognizant of what my colleague has raised. May I also say that the views of Advocate Jan Ferreira was documented and expressed in an opinion which he provided Mr. Sean Abrams, dated 5 August 2015. And it formed part of the record produced in the provincial High Court decision, which set aside ultimately the decision that had been taken not to institute, not to proceed with charges against Advocate Jiba. So there is nothing surprising about what had resulted in Advocate Ferreira reaching that decision. May I also say that there isn't only one contrary view, there has been at least 4 different views expressed, all of which we have endeavored to put before you so that you don't get a one-sided view. The question of the legality of the procurement of those views is something for argument. But ultimately the subject matter of Advocate Ferreira's opinion, in our view, is something that you cannot avoid dealing with and having to come to a conclusion on your own based on the evidence that is before you, which would include the memorandum provided by Advocate Ferreira and by other prosecutors. Because it is precisely those issues that the courts have spoken on and that what resulted in this inquiry being constituted.
Your view that the fact that there are other contrary views to just this one view would not leave the parties hamstrung. So the inquiry can proceed, therefore, with Advocate Ferreira's evidence
No,
without rendering the proceedings and making matters difficult for the parties when they cross-examine Advocate Ferreira.
I would be loath to
Yeah.
to take away any of Advocate Jiba's rights to a fair trial, which may in future ensue in a criminal proceedings. I am merely saying that what is already before you
Yeah.
is not only a one-sided view,
View,
but all the views that we were able to find have been put before you. Those views are but those views. Ultimately, the subject matter of those opinions
Yeah.
must be considered by you. I don't think you have an option. That's what the courts did, and it's that what Advocate Jiba answered to in her answering affidavit in the General Counsel of the Bar application. There is a version that has been put up in those papers, and there are court dicta that have dealt with the very subject matter. I'm simply saying that what I am prepared to accept for these proceedings, that the contents of the memorandum reflect the views of Advocate Ferreira as the time is when he wrote his memorandum, and I will not take him through that memorandum painstakingly, but he will confirm it to be his view then, and whatever his view is now, I will ask him. The inquiry can't avoid dealing with those issues. That's the only point I'm taking. But accept that it is his view and what resulted in it, and you can assess the different views in it. And you must make an assessment in that Advocate Jiba does have rights to a fair trial as well. I can't move away from that. We may very well reach the same issue in respect of Advocate Nomgcobo, because there are going to come up witnesses that may very well deal with that, and there may very well be, I can't ascertain with great certainty what was the status of the charges that had been initially contemplated against him as well. I'm actually haven't reached that bridge in the evidence, but it's by the very nature of this inquiry that's there. I did tender to my colleague that if he felt that there was prejudicial rights and any witness should give evidence in camera, then to protect rights, we would not be adverse to that.
Madam
Okay,
Chair,
thank you.
perhaps if we could just be of assistance, there are no pending charges against Advocate Nomgcobo, so we're not quite in the same boat as my learned colleagues on my right. But I certainly understand the predicament they're in, because I think it could be extremely unfair for a person who may still have to go through a criminal trial to have to ventilate all the issues in this court, which is a completely different, not this court, in this inquiry, where there's a completely different scenario as to the way evidence is presented, what is admissible, what's not admissible. So a whole lot of evidence could be dealt with here that might never be allowed in the criminal case, for instance, and vice versa. So I just think it is a difficulty for the panel. Thank you, Madam Chair.
Thank you. Want to respond to Ms. Bowers?
Yes, Madam Chair, I would like to do that. What we're not saying is that they are not. They are all the aspects that are covered in Mr. Ferreira's affidavit should not be dealt with. I mean, there is his views on the Breitenbach memorandum and the.
Sorry about that.
No, it's all right. Thank you. So we're not saying that you know, there is no assistance that this witness can give to the commission as far as the Breitenbach memorandum and the debate around those are concerned. But what I think would be very important, and you have different views on different views that are contrary to Advocate Ferreira. But what is important is to have the view that creates a legal status, that establishes a legal position. The decision whether to prosecute or not would place us in that position of deciding how to go, how far to go with him on the evidence he wishes to tender. We accept that he has very strong views about his decision to prosecute Jiba. That's his view. He's entitled to that. But what we think is highly prejudicial is for the inquiry to be exposed to because these other views are not given on oral evidence. They are presented as evidence to show that there should be fitness questions raised about Advocate Jiba. If the NDPP currently has taken a decision to prosecute, we say it's not fair to even ask Advocate Jiba to respond to a potential prosecutor in this inquiry, because we don't know whether he might well be appointed as the prosecutor again. So we don't know. We don't think it would be fair to expose Jiba to that kind of situation. It's prejudicial. And we think it's inappropriate for a potential prosecutor to come and root for his position in an inquiry like this, to come and say, well, I do have a good case, I will prosecute her, and this is the evidence I'm going to present. Because it's intended to pollute to pollute your minds about how you see Advocate Jiba. And we think that it's important to have that decision from the NP and from the NDPP that gives us certainty as to what the status of that criminal proceeding is, and it would tell us how far we go with this witness. It would help us to do that.
And I think an added difficulty or a particular difficulty is that we don't know whether we will ever have Ms. Jiba prosecuted in this particular matter. So whatever we do, whatever we say is just mere speculation. That's the particular difficulty. But unless you want to say something, let me give my panelists an opportunity to say something.
Let me just understand, and I understand the position that you adopt and the questions about prejudice. What I'm trying to understand is, her answer is the documents are in any event before us. His affidavit is before us. The affidavit of the matter that was before court. When the decision was taken to set aside the decision not to prosecute. So those papers are, in a sense, before us. The difficulty that you anticipate is cross-examining the witness on the papers that were before the court, because it will reinforce. It's not whether we accept those documents, is how then you engage with those papers. Is that what you say the difficulty is?
Firstly, I think the absence of a current decision on whether or not his decision to prosecute should be upheld or not. Because if for example, the decision of the NDPP is that the prosecution should not go ahead because there are no prospects of success, it determines how we see how we can engage with the witness. Strong views about that, about whether I mean, for us, it would, you know, we don't want you to be settled with a situation where Advocate Jiba has to debate with this witness about whether she should be prosecuted or not, when there is in fact a decision that says the prosecution is not going to go ahead. So
You are saying that then that engagement would be different because of the decision that's taken.
no, so
that-
no, but no. Perhaps let me try and clarify this. What we have today is a witness who is a potential prosecutor in a potential criminal case against Jiba. This witness who is a potential prosecutor in that case, in that case, is here to say that when he was engaged with these issues, he had a very strong view that the prosecution should go ahead. But we know that that decision may well have been set aside by the NDPP. And this is where we would have liked your assistance if you had subpoena powers, would have said, please subpoena the decision so that we all know what the current decision is. And of course, I mean, the possibility too is that if the NDPP decides not to proceed with the prosecution, they will give reasons why. And that would help us to engage with him on whatever views he has about the merits of his decision to prosecute Advocate Jiba. So we say the prejudice is in asking Advocate Jiba to engage with this witness in the absence of a potential contrary decision that may well be heavily motivated by the current acting NDPP. Because it would help even the inquiry, it would help the inquiry to see how far we can take his views, his very strong views on the issue. Because all we want to confront him is to say, well, you have strong views about the prosecution of Jiba, but your views now they make no difference, because we now have a decision from a senior prosecutor saying there's no prospect that a conviction can be secured on the evidence you think you could rely on to prosecute here. And we're denied that opportunity without that decision. So what we were really imploring the inquiry to do is to encourage the NDPP to release that decision, whether to prosecute or not. If the decision is to prosecute, of course, a whole lot of other rights issues get engaged. For example, is it appropriate for Advocate Jiba to be asked to answer questions that are a subject of a criminal case in this forum, without violating her rights, the rights that she has? And I understand this is a disciplinary hearing, but I think we have to be sensitive to the fact that there may well be a criminal case going on, and she would have to answer the criminal charges which are now being debated in this particular forum. So what I'd really, yes. I beg your pardon, it's not an inquiry, it's not a...
Even your attorney is trying to tell you it's not a disciplinary inquiry. What you had said was it's a disciplinary inquiry.
Okay, it's an inquiry. I apologize for that. Thank you for the...
Because if it had been a disciplinary inquiry, I think we wouldn't be asking all these questions. Yes. Yeah, so it is not. But there's a difficulty.
And I'm also
Before you proceed, I needed to ask this. Do we know if a decision has been taken?
And this is what we would want the inquiry to establish, because if the NPA has made a decision, then it's material to how we engage with this witness, because of the scenarios that may arise from that particular decision. If the decision is to continue with the criminal prosecution, of course, she can immediately assert her rights, which she's entitled to assert, and she would be entitled not to engage with the witness at the level of the merits of that issue, and that leaves us in a predicament. But also the appropriateness of a potential prosecutor in that case coming to give evidence on a matter that they're prosecuting in a criminal trial. It just doesn't seem to us that it is appropriate for a prosecutor to show up in a hearing like this one, in an inquiry like this one, to say, yes, I am prosecuted, or I took a decision to prosecute so and so on charges that I strongly believe are meritorious, and then meet that same person in a criminal court and prosecute that person. It's just unseemly to have that kind of situation.
But does the fact that he is prosecutor currently,
no, he's not.
cast in stone?
He's not a prosecutor currently.
But he's the one who's dealing with the matter.
No, he's
up
not.
to now.
No, he's not.
So
that's why I keep saying potentially can be re-engaged.
Yeah, it's potential. So he's not the prosecutor.
Oh, sorry, I'm instructed that he is, in fact, the prosecutor.
He is handling the case.
Yes, he's handling the case. No,
But cast in stone, isn't it?
it's not cast in stone.
Yeah. So that shouldn't really be a difficulty. That you have a prosecutor, a potential prosecutor coming before the inquiry to give evidence. If he gives evidence and there are possibilities that Advocate Jiba might be prejudiced, it's easy. The matter can be given to somebody else, isn't it?
No, but this Mokgoro, the difficulty is that you have to be uncompromising on the fairness question. Is it really fair to expose Advocate Jiba to that kind of situation, even if it's given to another person? Is it fair to expose her to that kind of situation where she has to now decide how far she goes with her evidence here, because she knows that she will be meeting a prosecution elsewhere?
Or because she doesn't know that.
Or that she doesn't, yes. So, sorry, Madam Chair, can I just take instructions from the matter? Sorry.
You can proceed.
My apologies. I'm instructed that, in fact, a decision has been taken. That has, in fact, been communicated by the spokesperson of the NPA. But she has not been notified of that decision. And what we would want is that that decision is released for purposes of dealing with of Ferreira. That we actually given that decision. Because if it's been made public, that decision has been made, we don't understand why she has not been notified of that decision and given the decision.
Is there anything? Yeah. Yeah. Okay. You may proceed with what you were going to say, but I think we need more information about the decision. Where does it lie right now? And what is the decision? I think not only Ms. Jiba needs to know. If we have to proceed with this witness, we would need to know that the way you have articulated it. Okay. So we might need to, I don't know when you can get that response.
On the strength of I would call it a ruling, we would then approach the NPA and convey that this inquiry has expressed a view that we have, which is that the decision has to be communicated, and then of course they must then release that decision.
We were going to adjourn for about 5 minutes and just quickly deliberate a certain ruling, a ruling with certainty, and then we'll take it from there.
Thank you, Chair.
Pardon me, ladies and gentlemen. Yeah.
I did. I simply wanted to say that I am not aware of a decision that had been taken by the Director of Public Prosecutions in the area in which the matter arises. I have been provided documents of a view expressed by a Director of Public Prosecutions in another province. So I'm, as I'm sitting here, not aware of a decision that had been taken by the DPP, what would it be, North Gauteng or South Gauteng? North Gauteng, in respect of a charge arising in that area. I want to be careful about how I'm phrasing this, because I have been provided with various opinions, and one much taken later after the High Court decision. The status of that, I don't know.
And I think it is for that reason that we don't have a decision before us. Okay. So we will adjourn for 5 minutes and give consideration to these articulations, and we will make a decision. Okay, within 5 minutes. We adjourn. Thank you for your indulgence. Are you ready? We have considered and the submissions made by the legal representatives and the evidence team. Okay? And we are concerned that we have to make an extempore ruling on an important issue which has not been foreshadowed. Taking into account the nature of these proceedings, the panel therefore rules that the parties must submit to the panel brief heads of argument by tomorrow morning, the 24th day of January 2019 at 8 hours 30. Providing detail on, amongst others, 1, how the right to a fair trial in terms of Section 35 of the Constitution of South Africa is impacted where the versions of the evidence of both Advocate Jiba and Advocate Ferreira have already been ventilated before court in the matter of Full versus NDPP 2018-1 SACR 436 GP. Rule 4.7 of the rules of this inquiry pertaining to the right to cross-examination. The parties shall, in addition, also confirm whether or not a decision regarding to prosecute or not to prosecute Advocate Jiba has been made, has in fact been made by the NPA. Ne? Yeah, kindly do that. And if so, furnish this inquiry with a copy of that decision. And it has to be done by today. Today, the 23rd of January, 2019. Okay? Now, the ruling itself is made on this day, 23rd of January 2019. Okay? Thank you. Yeah, we'll finish it with a copy of the ruling. Okay? Yeah, no, certainly. Okay. Thank you. So it means, therefore, that we will adjourn until tomorrow morning at 10 o'clock. But it is very important that we apologize, Advocate Ferreira, profusely for getting you here today and not proceed with giving you the opportunity to give us your version of the issues. But the advantage that we have is that you are an advocate and an officer of court, and you understand and appreciate fully that sometimes matters turn out like this.
I do.
We appreciate your indulgence and thank you very much. But we also appreciate the fact that the matter has been raised, and it makes things easy for us because we would want to have these proceedings go as correctly or perfectly as possible. But thank you so much for the articulation of your views, which assisted us in making this ruling. Thank you. We adjourn, therefore, until tomorrow morning at 10 o'clock.